Hi, good morning. We'll start through the docket. Call the first case.
Judge, this is a motion for default on a termination of parental rights case. I don't know if I need these.
If you want to have them testify, yes, they do.
Yes, Your Honor.
Raise your right hand. Let's have you placed under oath, please.
If you would, please state your name for the record.
Melissa Mask.
Jeff Mask.
And the two of you came into my office and signed a petition for termination of parental rights, is that correct?
Yes, ma'am.
And we filed that on or about August the 25th, 2025.
Yes.
Everything in that petition was true and correct to the best of your knowledge, is that correct?
Yes.
And we've had those served on both respondents in this case, Alexandria Danielle Johnson and Joseph Mariotti, is that correct?
Yes.
And neither one of them have filed a responsive pleading or an answer to this matter within 30 days, is that correct?
Correct.
Are you asking this court to terminate the parental rights of both respondents today in this court?
Yes.
And you understand you'll continue to have custody of this, you've had custody of this child for some time, is that correct?
Since he was a year old.
Okay, and you'll continue to have custody, no guardianship is necessary today, but you'll continue to have custody until we can get back to do the final adoption.
Yes.
You understand that?
Yes.
Are you available on December the 4th for a final adoption, if that's a
Yes.
good date for the judge? Judge, that's all.
All right. The motion for default judgment is granted. And then my understanding is you're going to have a hearing on December the 4th.
That's a good date for your honor.
I mean, I have a jury trial in a criminal case. December the 5th, I'm here. December the 5th is my chancery day. Is that the day you were talking about?
Well, I was talking about, I think I've got the Green case in front of you on December the 4th. Oh, that's Turnbow, isn't it? It doesn't matter.
I mean, it doesn't matter to me. Judge Turnbow can hear the, I've granted the default. If you want to put on your proof regarding grounds in front of him, I don't think there's any reason that can't happen, so.
We will do that, Judge, on the 4th, if that's okay.
All right.
Thank you,
would-
Judge.
All right, thank you. We have someone coming in on Zoom. Good morning.
I believe Ms. Collins said
All right, Miss Tiffany Dawn, were you at one time known as Tiffany Dawn Amos?
Yes,
All right, but you are now known as Tiffany Hillard.
yes,
Okay. We are here today on several motions. One of them is a motion to appoint a guardian ad litem. Another is to appoint a motion to appoint an attorney to represent you. Do you understand that to be the case? You have requested an attorney.
yes.
Right. Do you have anyone in mind to select as a guardian ad litem?
You what?
serve, I believe.
All right. I'm going to appoint, Ms. Hillard, I'm going to appoint Ms. Mickey Furlong Smith as the guardian ad litem for the minor child or children in this case. I don't know what the noise is in the background there, but obviously it's going to. All right. I'm going to appoint Ms. Mickey Furlong Smith to represent you. And I'm sorry, to represent the children as a guardian ad litem. And I'm going to appoint Ms. Lynn Coffenberry to represent you as your attorney, so.
Okay.
Your attorney will be in touch with you. I'm muting your device because of the fact there's a lot of background noise that's coming in, so.
Okay.
Then the other is a motion for default against the respondent father, Jerome, is it Jeremy Walker Amos? Is that
Yes, Your Honor.
correct?
And if you both will raise your right Get you sworn in. And will you state your name for the record?
Jamie Amos.
And will you state your name?
Anthony Jacob Amos.
Okay. And we filed this petition to terminate the parental rights of both the mother and the father, Jeremy Amos and Tiffany Hilliard Amos. Is that correct?
Yes,
And to the best of your knowledge, everything that was listed in that petition is true and correct?
yes.
And since we filed the petition, have we received a response on behalf of the father? No. And prior to filing this petition, or prior to, is it your knowledge, your best knowledge that he is currently incarcerated?
Yes.
And do you know how long he will be incarcerated for? Right. And
How long?
30 years.
Okay.
yeah,
I don't know that to be
If
factual,
24
that's what I was told.
it's a combined sentence of 24. And did he have any visits or pay any child support prior to his incarceration?
No.
And how long has the minor child been in your care and custody?
2.5 years.
About 3 years.
And did you receive custody through a court order?
Yes.
That's it, Your Honor. We asked that.
All right, on the motion for default judgment will be granted against the respondent father. I would basically reserve the finding of termination, I think, of his rights until we have the final hearing on the mother as well.
Okay.
Obviously, I don't want to terminate one parent's rights without the other.
Okay.
So the default judgment is granted, but we'll reserve the hearing on the termination.
Okay.
Then it may be necessary for you to redraft your order.
I'll amend the order. Yes,
All right.
yes, sir.
Let me hand that back, officer. Then, as far as this court is concerned, if you want to set it for a hearing after Ms. Smith and Ms. Coffenberry have had an opportunity to get familiar with it, then we'll go from there.
Thank
All
you.
right, thank you.
Matters in this.
How long do you think it'll take?
Probably, I don't think too long.
It's a paternity matter, so your designation of primary residential parent and a residential schedule judge.
So
So
most of the day?
probably.
I'd say
I mean,
half a day. The first part of this did not take that long, did it? I don't recall it taking very long.
Well, this will be the longest contested case that we'll set that day, let's put it that way.
Is the 26th, is that what you said?
I thought that's what you said.
January 27.
I have a matter in Hickman County, but I also have a matter here, so I'll go ahead and do the matter here and just send someone else on my.
All right, January 27th.
Thank you, Judge.
Thank you, Judge.
Good morning. You'll raise your right hand and let the clerk place you under oath.
State your name, please.
Kelly Melton.
And Ms. Melton, you, prior to being Melton, right, that's all I want. Okay, so you adopted 4 children,
Yes, ma'am.
and they presently have your former name, or your name Street,
Yes, ma'am.
correct? And you would like to,
Yes, ma'am.
and, you are not doing this for any illegal. This is our you.
No.
No, you just want them to have the same name as you.
Yes, ma'am.
All right. All right, I've signed your order granting your name change request. So,
Thank you.
thank you. Good morning. If you'll raise your right hand, please.
I do.
You are Stephanie Marie Clark.
Yes.
Ms. Clark, you've asked to, you filed a petition to change your name. I'm required to determine that there are no illegal purposes in your doing so. Are you asking to change your name to avoid your just debts or creditors?
No.
Are you asking to change your name to avoid criminal prosecution? You have indicated the reasons why you want to change your name, and that's to be consistent with your children. Is that correct?
Yes.
All right. Do you have an order prepared? All right, Ms. Mahoney, I've now changed your name, so you may get a copy from the clerk's office a little later in the day when they have it transmitted, okay? Thank you. We have somebody, Anthony Kirby's office, that's supposed to be on Zoom, that may be Ben Brown that's in the waiting room. Let's see if that's the case. All right, never mind. Mr. Brown, we're going to put you back in the waiting room until your case is called. We were trying to determine who you were. Thank you. All right, so no, you have a motion to approve the payment of your guardian ad litem fees?
Yes, Your Honor, and there was an order entered at the time of my appointment that, whereby the petitioner, Ms. Walker, had agreed to pay my fees for me to serve in that matter. I have, on the initial bill, I had $1,575, and then immediately after, there was something filed because there was a potential contempt or attempt to change an order we had done, and of course, that's been non-suited. So I had an additional amount of money of $525 that went into that time. So I'm asking for a total fee of $2,100.
All right, there's no objection filed, and I find your fees to be reasonable, so if you'll prepare an order, I'll gladly
Yes, Your
sign
Honor,
it.
and Ms. Jones will be the one to pay those.
Correct.
Thank you.
Good morning, Your
Good
Honor.
morning.
Tiffany Oliver here on behalf of Aaron Asphalt. We're here today on a show cause order for defendant Alpa Construction. We were previously here weeks ago on plaintiff's motion for sanctions and default judgment. The court entered a show cause order asking defendants to come here today and show cause. We did have to reset this because there was a change in the calendaring, but defendants were served with the notice of resetting the show cause for today. And it appears that they are not here to show cause.
All right, well, so what are you asking me to do since they're not here again? So,
Your Honor, we will reassert the request that we made in our motion for sanctions and default judgment, that the court enters a sanction. Liability's already been entered on our default judgment. The only issue remaining is damages. And we allege a claim under Tennessee's Prompt Pay Act, and as such, they are liable for the liquidated damages that are laid out in there. It provides for $300 per day for each and every day that they do not, that the money that was owed was not placed in an interest-bearing account. Defendants have not shown that they placed that money in an interest-bearing account, and as such, plaintiffs should be entitled to the money, the liquidated damages under that, as well as the interest under Prompt Pay Act, which is a total amount of $168,000 plus 1.5% interest per month.
no answer having been filed, and there's been no compliance by the defendant with any of the court hearings, then I will grant your request. So,
Thank you, Your Honor.
Put it on second call. Any time estimate? Rest of the day? Okay.
We have worked out some motions, talk about that. We estimate about an hour.
All right, you've heard that you're behind the Ferguson case, which was set on the docket as the first contested case to be heard today because it had been passed, I think, one time before. Is that right? Twice. So I'm going to be taking the Ferguson case up, so you'll be behind that. It'll give you plenty of time to work
Yes,
whatever you can work out. So,
yes, sir, thank
all
you.
right.
Runner, if we could bring my client
We're asking him to start his video, so there he is. All right, on the Brown case then.
Yes, Your Honor, that was a matter that was set at the first of the week on Monday on your docket, and it got continued until today, and I hate to ask, but I just need one opportunity to speak with my client shortly, and then we may be able to resolve that matter, I don't know, but I've been
That's
in
fine.
court every day for the. just
You're in
as
the
Your Honor
Ferguson
said.
case, and that's what's next up, but I'll give you an opportunity to try to talk about your other matters before we take it up.
If we can talk about this one, and then we'll be ready to start on Ferguson.
Then we'll just take a short recess
Thank you,
and
Your Honor.
let Mr. Kirby know that his case is already come and gone. So,
Just stay put, Mr. Brown. We'll call you back in when we're ready, okay?
all right, we'll stand at recess for probably around 15 minutes. All right. My understanding is you have an agreement or an announcement to make on the
We
Brown.
don't have necessarily an agreement or announcement, Your Honor, but I will explain what's going on. On Monday, Ms. Roberts and I were in agreement that we were going to try and find a resolution to this case. Ms. Roberts has conveyed to me just now her proposition for the resolution in this case. I'm not going to be able to discuss that with my client and get it resolved today, as he is coming across country with an RV because he currently has nowhere to live. The wife has kicked him out of the home. So I'm going to make a verbal motion to continue. It seems like y'all got plenty to do today anyway, so that I've got some time to discuss the proposition with my client. Also, Your Honor, I have not been able to file an income and expense statement or an asset and liability statement because of communication issues with my client, which I do think that I have been able to resolve, and I don't believe that we have the same from Ms. Roberts either.
I have mine ready to submit.
Well, it sounds like to me, from what I'm told, that Mr. Van Voort, in your case, is going to take most of the day, and then after that, I have a case that's behind that, the Smithson versus Dixon, that has a number of motions, so it doesn't sound like we're going to get to your case.
Your Honor, the only thing that I want to put on the record and make sure is that this is a situation on where we had filed the divorce because there's some significant issues. It hasn't risen to the level where I felt it was appropriate to get an ex parte restraining order, but it could rapidly get that way. We appeared on Monday, wherein my client, the testimony would show that my client had said that her husband, Mr. Brown, had left and gone to South Carolina to be with his brother, and was continually texting and contacting and emailing about his mental state, and that he didn't know what he was going to do. He has some significant mental health issues that he manages rather than by conventional medicine, by the administration of illegal drugs, and self-medicates himself. Parties have an 11-year-old child. And so it's a scenario where he had not been in town, and as I understand it, had not been in communication with his attorney to get ready for the hearing. We passed it to today. I was in court on both Tuesday, Wednesday, and Thursday of this week. So again, Ms. Jackson Smith and I were not able to discuss resolving the matter. But again, and then as I understand it, Mr. Brown drove with his mother to Colorado and is bringing an RV home to live in. So it's a scenario where it could escalate pretty quickly. If Your Honor's inclined, because again, time constraints, I understand that if Your Honor's inclined to grant this continuance, what I would ask is that Mr. Brown be ordered to submit himself to an extended panel nail bed test between now and a certain time. I give him 36 hours to go and complete that. I don't know what time he plans on arriving back from Colorado.
I have not heard anything in this case up to this point, correct?
No, sir, Your Honor.
When's your next chancery day? On what?
That's next Tuesday. It's because I have to be in front of you in Ashland City on Monday, here on Tuesday, and then back in front of you on Wednesday.
Again, Judge, I don't know that I can get it done that fast.
All right, what's your next day after that?
11/6.
I should be able to do that.
11/6?
Judge, I apologize. I left my calendar in.
All right. I tell you, you're not in front of me because I start the State versus Cordarius Godwin rape trial on the 6th here in Charlotte, so.
I don't, and that's a Judge Lockhart MASH day again. But that's also a Wallace day and a Turnbow day in another county. That's the only thing I'm here on 11/12.
I'm here on a criminal trial.
Well, if you're here on a criminal trial on the 12th, it's not going to be possible for you to hear this case,
I
right?
think it would.
Oh,
think it
that,
would
I
be
knew I had,
interesting,
I knew I had something on the 6th, Judge, I'm having eye surgery. So I knew I had something going on. That's next Thursday, and I'm having eye surgery, and I won't be able to see for approximately 3 to 4 days.
After the 12th.
We have Marlin versus Marlin on the 25th of November. And is that expected to last all day?
It's a contempt on failure to pay alimony and their counter petition to modify alimony.
I mean, that's you and
And Mr.
the
Bates.
case I'm hearing, and Doug Bates, the 17th, and
I mean, I don't mind putting it on that day.
I fly out that day.
Roberts.
I'm looking, Judge, I'm sorry. I apologize, I didn't get done in court over here until after 5 yesterday, and I left my calendar in my car with my other bag that I didn't go back to
Well,
the
double check
office.
on, if you need to
So,
go out to your car to check it, that's fine. My only thought would be, it sounds like that's probably the first day we can give you. I am going to grant your continuance because it's unlikely that, this was not a regular chancery day that I had assigned on my schedule. I gave it out in a lapse of judgment on my part to, because I thought, that there were some things that needed to be heard. So we just concluded a multi-day criminal trial yesterday yesterday afternoon. This case is the last on the docket, so I'm going to bump it to that December the 3rd. Is that what it was?
yes, sir, Your Honor.
December the 3rd.
I think I've got to be here on a Mangrum final hearing. So, I'm
All right,
sorry.
then that settles it.
Yes, sir.
December the 3rd. In the interim period, both parties are going to submit themselves to an extended panel hair follicle. I have no evidence before me other than argument as to the fact that there's any drug use. So
That's great.
what's good for him is good for her. We'll order that both of them undergo
Can we do a nail bed test, Your Honor?
whatever test that is requested, nail bed test, and that will be within the next 48 hours. So
Within 48 hours.
Judge, is there any way that we can get it 17th? We can at least get it to Monday? Because it's Friday, it's Halloween.
that's true.
We got Saturday, Sunday.
Close of business Monday,
Close of business Monday.
the 3rd of November
Yes, sir.
at 6 p.m. Have the test performed by that time.
I'll do it. Thank you.
Ms. Roberts is going to draw the order.
Thank you, Your Honor.
All right.
Thank you, Your Honor. And Mr. Brown, I'll be in touch, okay?
And we are ready to take up the Ferguson. I'm sorry. Yes, sorry. You and Mr. Odom were sitting there so quietly, I hated to even mention it. So. All right, page 4, in the matter of Kaz Alexander Bird. This is a motion to discontinue visitation and set a final hearing.
It is, Your Honor. The minor child has, number one, the mother has not been really attending visitation much and makes excuses as to why she can't be there. She's currently got several more criminal charges while this case has been pending. She's been aloof about it. Additionally, the child gets sick after every visit. So they're having to take the child to urgent care or to the doctor, and the doctor has asked that these visits stop also. That's not necessarily here or there, but the mother has a history of drug abuse. They have smelled alcohol on her at the visits, and frankly, she's not here today, so we're asking that this court grant us the ability.
You represent her, Mr. Odom?
Judge, I'm appointed to represent her.
I'm not 100% certain what happened, Judge, but we received this motion to set. It was styled motion to set in a letter. It had a motion to set and discontinue visitation with it. I came here this morning believing this was just a motion to set. It was on my calendar as a motion to set. Ms. Honeycutt, a few days after, who represents the father, had sent out an email saying she couldn't be here and asked for alternative dates. But there's no record in my file where we forwarded this to my client. And I don't know that she knew to be here. I know Ms. Duke says that she included Ms. Bird on the certificate of service. I've talked to my assistant about it this morning after I realized there was more than just a motion to set on the docket, and she can't recall forwarding it. But it would be our practice at our office to forward these type motions with a cover letter to our client, and that is not in the file. The last email communication in our records are the one from Ms. Honeycutt, probably around October 7th or so, about the same time this would have been received in the mail. But I did try to call my client this morning. It goes to a disconnected number. The call wouldn't go through. And so that's my circumstances, Judge. I asked that the motion be continued to one day next week to give me an opportunity to probably go to her residence and try to find her. And right now, Judge, she has supervised visits. That's all she has. This is not unsupervised visitation. It's supervised.
If I may briefly respond.
You may, I also want to hear from Ms. Smith.
Oh,
She's the guardian
Ms.
ad
Smith.
litem, correct?
She is, Judge.
Well, what I know is what I've been told, and I actually have been involved with this case. I was a guardian ad litem in the dependency and neglect case, and I know Ms. Bird has always been, during the pendency of that, a little sketchy, and that's what I know. But I
I
definitely,
think sketchy is a legal term, if I recall my Black's Law Dictionary, so.
well, just look it up. But anyway, so like I said, I know what I've been told. I don't doubt that she's missed visits. She did that in the dependency neglect case.
Are you, well, number one, I'm hesitant to suspend all contact between the mother and the child or children without some sort of evidence being
Right.
presented to me. Are you prepared to do that today?
We are prepared to do that today. I am sympathetic to Mr. Odell's position on this regarding whether or not his client received notice. But I will say, based on the fact that the mother's phone is disconnected and I sent notice to her last known address, I do that in any case that's ever been with the Department of Children's Services because that's what the department does. We are prepared to move forward today. I am sympathetic.
When is she scheduled to have another visit?
My clients offered her Saturday at 5, and she has not opened or responded to that email or text, I'm sorry.
What do you have available next week? 11/2 is Sunday. Is that okay with y'all?
11/6.
Oh, 11/6. Speak up. What about 11/6?
You have a TPR, where is it? Here. Facing other criminal charges, and she's got criminal court that day.
Anything else?
I've got to be in 2 other courts already that day. Humphreys County's got criminal docket and Hickman's got chancery.
Hopefully
11/4. Yeah, 11/4 would be fine. 11/4, okay.
So 11/4, you could be here in the morning. So y'all are just going to tell the judge, whoever the judge might be, you're just going to insist that that judge take the matter up very first thing, correct?
Yes, I'm sure.
I'm
sure.
going to set it, I'm going to continue this, but I'm going to put an order down that the visitation is suspended until that hearing. And I only do that because obviously if there's some allegations made that I haven't heard any proof on, I want to give the mother an opportunity to be heard and to respond and to be here to hear that. But in the meantime, protection of the minor child or children would behoove me to go ahead and suspend the visitation since it's only next week. So we'll just suspend the visitation until that hearing at 9 o'clock on the 4th of November.
And I'll have my clients reach out to her, and I'll have, I guess, Mr. Odell will reach out to her anyway.
Right now, but I'll go to the last race.
All right.
Thank you, Judge.
I mean, you're going to have to find some way to get in touch with your client if her number has been disconnected, but,
I have the address.
well, I'm continuing it out of an abundance of caution for the mother's protection. But in my opinion, she is entitled to this continuance, but, you know, it'll be up to the next judge as to whether or not it goes beyond that, because at some point, her responsibility is to stay in touch with her lawyer, so. All right, that's fine, thank you. On this one?
Really, the crux of the case is submitting all of her criminal convictions, so that we can go through that.
This is a termination of parental rights.
Yes, Your Honor.
Does he have a lawyer? Has he?
He does. Ms. Honeycutt. I told her I would text her any dates we got.
Who is that?
I can do the 6th. Is there another date after that? Is there a date in March? The 5th and the 6th both work for me. Okay. March the 6th. I'll text you.
March 6th?
Uh-huh.
You know what that day is, right? Why do I continue to try to educate you all of you lawyers about certain historical days?
I do know that date, though.
Yeah, then what is it? Not the Ides of March. It's March 6, 1836,
You're
the
right.
day the Alamo fell in San Antonio, Texas. So I always thought that my namesake, or that I was named after David Crockett. And so I've always had a love for history, and I've been to the Alamo in San Antonio several times. But the fact of the matter, my mother somehow thought mistakenly that I was named after David in the Bible, but I know it was after David Crockett because Fess Parker was playing David Crockett on Disney while I was a child, so I knew that was why I was named that. So
That's perfect, Judge.
I'm sure it is. All right. And we are ready for the Ferguson case, is that correct? All right. All right, then we will terminate the live stream due to the fact that there's information or testimony that's going to be requested not to be live streamed. So